any further ado, today's webinar, to get started, today's webinar is the 2024 FinCEN Financial Crimes Enforcement Network. That's what FinCEN stands for. The new section 5336 and the quote-unquote beneficial ownership information reporting requirements, otherwise known as the big acronym there, FinCEN BOI. This is my background slide. This is our general disclaimer slide. And we'll go ahead and get started. So the topic of FinCEN BOI is a hot topic in the tax professional legal community. I would say that pretty much a lot of people are hearing about this or starting to hear about this. This has been kind of floating around for a while, though, because the Corporate Transparency Act has been signed for a while and been part of legislation for a while. I would say the general population, though, probably does not know a lot about this new reporting requirement or even the law behind it. And there's a couple different ways that I think it'll come to their attention. They could be told by their CPA when tax returns are being prepared that there's this new reporting requirement. They could hear it from a friend that had to do it that said, hey, you may want to look into this. They may even hear it from their bank that says, hey, look, you have a business bank account with us. We need to know that you're FinCEN BOI compliant before we can, continue working with you as a business client. So there could be a wide variety of ways where this is kind of like unannounced and kind of new information that's thrown upon people. But I will go forth and say that I don't think this is a very relevant, topic for a lot of people, generally speaking. One thing to note is that in the United States, for business entities, and this probably goes against what, if you watch a lot of Hollywood movies, people get this idea that there's a lot of this information sharing, that a lot of information can be easily found on a wide variety of topics. But when it comes to businesses, there's a lot of business entities that are created every year annually in the United States. Pretty much anyone can create a business entity. There's no limitation, like foreigners are allowed to create business entities. There's no limits that we have on those. But there is no central database of where all of the information about who created an entity, where it was registered, what type of business it is, that doesn't really exist until now. And this is what basically is happening, is this centralized database of business entity information is now occurring. But previously that has not been the case. And so basically there are a lot of business entities that have been created that have been in the United States that are doing what we call nefarious activities in a wide variety of areas that law enforcement is trying to crack down upon. Our counterparts in Europe and other foreign countries have taken more of a lead on beneficial ownership reporting and those requirements than we have. We're kind of playing catch up here as far as our beneficial ownership reporting, and then the ability to transmit that information to law enforcement, foreign countries, state and government agencies. So those things, this is all kind of a brand new thing that we have here in the United States right now. This is a report by the Treasury Department where they basically conducted a study of IRS cases from 2016 through 2019. And they basically found that legal entities were used in a large, or what they call substantial proportion of those cases to perpetuate tax evasion and fraud. And specifically, quote unquote, what we call shell companies. Those were commonly used by perpetrators to commit fraud and tax evasion. So it's an issue that's been kind of gathering steam for actually a very long time, even prior to 2016. The law that we're going to be talking about today is really it's been around. It's the foundation for it started a very, very long time ago, but it's really crescendoed over the last 2 to 3 years. And that crescendo occurred in the NDAA, which is the National Defense Authorization Act. And basically, as part of that act, we now have what's called the Corporate Transparency Act, which is tucked in there. The Corporate Transparency Act, the policy on that is to prevent and combat money laundering, terrorist financing, corruption, and tax fraud, while also balancing the burden on business entities to disclose their information, business entities within the United States disclose their information. So you have those two policies that are kind of counterbalancing as the lead into the Corporate Transparency Act. Like I said, this stuff has been around for a while. It's kind of gathered steam. So starting in 2012, we have customer due diligence rules, or the CDD rules, that really kind of started this, kicked everything off. There was this advanced notice of proposed rulemaking, or the ANPRM, that then became notice of proposed rulemaking in 2014. We had final regulations for the CDD in 2016, and those really have to do with financial institutions and opening up bank accounts with financial institutions. For the beneficial ownership reporting requirements, the advance notice of proposed rulemaking came out in April of 2021. We had the notice of proposed rulemaking, and at the end of 2021, we had a ton of comments that came in, which was fantastic. And then final regulations were put out in September of 2022. And basically on the left-hand side of the slide, you see, there's also, we have 30 other foreign countries that we've looked to that have done their own BOI process. We have 100 other countries that are just like the United States that are committed to implementing a BOI process. So this is really kind of a global requirement that's coming into play and really taking steam here. And then I think it's also important to understand the people that wrote the law and kind of their kind of viewpoint about how the law should be implemented. So here we have a letter to the Treasury Secretary, Janet Yellen. And within that letter, I think one of the big things you'll find on page 2 is that they're urging the Treasury Department when they were writing the regulations to basically say, we want the law to broadly apply to as many business entities as possible. So we want a lot of business entities to be filing the FinCEN BOI report. And we want to limit the amount of exemptions to the narrowest amount of entities as possible. So this is really going to be a very large kind of catch-all filing. And again, I think it's not, U.S. person, non-U.S. person. That has nothing to really do with it here. It really is there a true business entity that we have? And then does that business entity need to file this report? And then going forward, does that report need to be updated or corrected in a certain way, shape, or form? That's kind of the crux of what we're dealing with here today. Okay. The other thing to keep in mind is that there's kind of a 3-part process here. So FinCEN, BOI, those reports and the regulations dealing with those reports are a first part of the process. There's this access rule about who's going to get the information, who's going to be allowed to see it, look at it, what are they going to do with it. And then the third part will be updating the CDD, which is what I previously talked about. That is the third kind of leg in what's going on here as far as rules that are coming out. The first 2 are kind of done. So this access rule just came out, and we'll talk about that a little bit later in the presentation. But the third part, the updating CDD, that's going to happen here in 2024. Okay. And what's going to happen under the access rule, again, we're going to talk more about this, but there's going to be sharing. So for example, when these reports are filed, the information that's contained in these reports may be shared with national security, intelligence, law enforcement. There may be state agency sharing. Then there may even be foreign government sharing. So for example, if there's a foreign reporting company that files this form and we have that information, if that foreign government where that foreign reporting company is located wants details on that filing, that information may be shared back with that foreign government and their specific law enforcement for that purpose. All the information will be housed in what's called a beneficial ownership secure system, otherwise known as BOSS, which I think is a fantastic name, but that's where the information will be at. They supposedly are giving it the highest security level, pulling out all the bells and whistles. There's a whole FISMA, which is the Federal Information Security Management Act, has deemed it a high compliance level, whatever that means. But the point here is that they are taking, all available resources to make sure that when this information is submitted, because there is a lot of personally identifiable information that they're requesting, there is a lot of sensitive information, but that information is kind of stored in a very secure place and not available to just anybody. The initial filing requirement started on January 1st, 2024. So basically the portal for FinCEN opened up where people could file FinCEN BOI reports. And yesterday, so January 8th, 2024, at a conference, Janet Yellen, Treasury Secretary, indicated that over 100,000 FinCEN BOI reports have already been filed. Year to date have already been filed, which is a large amount in just 8 days. And basically, she kind of made this quote here that said, look, we're sending a clear message to both people inside the United States and people outside the United States that the United States will not be a tax haven for dirty money. That's the real big, thing here. The United States basically not having the central database. It's easy to hide black money, dirty money in United States LLCs, United States entities. So that's what they're trying to combat there. Okay, so when is the BOI report due? I think due dates is always a good way to kind of kick off the specifics. So I started out with very general information. Now getting into specifics. So if you have an existing entity, meaning a business entity that was created before January 1st, 2024, you basically have, and this is the left-hand side of the slide, you have 1 year to file your BOI reports. That's due on or before January 1st, 2025. Under the regulations of the law that was passed, if you have a new company created on or after January 1st, 2024, the original requirement was 30 days. So for example, if I created my company on January 15th, 2024, I basically have until, call it February, call it Valentine's Day of 2024 to file. However, in November of last year, the FinCEN basically said, look, we're going to just for companies created in 2024, this is just for companies created in 2024, we're going to allow 90 days, okay, because this is a brand new law, brand new filing requirement. Instead of 30 days, it will be 90 days for any business entity created in 2024. However, if you create the business entity in 2025 or thereafter, it's still 30 days, okay? And again, that really has come out of a lot of concern. So if you read the regulations, the FinCEN BOI regulations, they're fantastic. They really try to do a deep dive into a lot of different things. They brought up a lot of concerns that people had in the comments. So when people were talking about, when the BOI report is due, people were saying, look, there's a time lapse. So when I actually register my company or create my company to the confirmation by the state, I'm losing a certain amount of days, which in some cases could take, I think, up to 2 weeks. And with a 30-day clock, if I lose 15 days just waiting for the confirmation to come through, now I'm on 15 days to file my report. There can also be a time lapse between alternative entity names. So if you're doing business as or trade names, all of which have to be disclosed, there could be a time lapse from that. There could also be, quote unquote, a time lapse from getting your federal taxpayer identification number, otherwise known as an EIN. That's the employer identification number. In lieu of that, there are these what are called DUNS numbers or LEI numbers. Can we use those instead? And so there's a whole host of kind of concerns about the timeline and kind of what could be used, what could not be used. And so FinCEN basically said, look, there's a trigger. Okay, that's what we're gonna use as far as when the timeline of the due date starts. So it's the earlier of when a reporting company receives actual notice that the company has been created or registration has become effective, or in some states this is what they do, they publish, okay, when all the new entities, okay, so whenever that's published, that would be when your timeline starts. In 2024, your 90-day timeline would start from one of those two dates. So the earlier of one of those two dates would be your trigger date. That would be your day one. And then you'd have 90 days from your trigger date to file your FinCEN BOI report. A couple other concerns. So what happens if my company had an exemption? There's 23 different exemptions to FinCEN BOI reporting. I talked about that earlier in the presentation about how the drafters of the legislation wanted to limit the exemptions, the companies that would qualify. We'll get into more of that here in a minute. But some people were concerned, like, hey, if my company was exempt before 2024, but ceased to be exempt after January 1st, 2024, then how does that really work? And so basically FinCEN came out and said, look, we're going to give you dealer's choice. You can either follow the 30-day calendar period, which is now the 90-day period, or you can use what previous existing entities get, which is the 1-year period. So whatever days are left within 2024, that would be how many days you have left to file your FinCEN BOI report. So kind of a hodgepodge mix there of the timelines of which you could use to file if you had a previously exempt company that's now no longer exempt in 2024. People were asking, can I get an extension of time to file? So for example, if you're talking about the other FinCEN report, which people I think know about, which is the FBAR, there's an automatic extension of time to file. That one's due on April 15th, and then you get a 6-month extension. People were saying, look, there's a whole host of things that have to go into figuring out the FinCEN BOI reports. I look at it kind of like an onion. When you see the report, there's a limited amount of stuff that actually is being presented to FinCEN. It's not a 60-page filing that you're doing here. But to get to that final information, it's this real detailed onion that you have to kind of comb through. And you start getting into more and more layers and deeper and kind of asking all these questions about, the information that needs to be provided. I think people will be pushed on some of these timelines, especially if they're, thinking, okay, it's been 30 or 60 days, I still have 30 days. You're losing time when you don't, get into the nuts and bolts of what needs to be calculated from that trigger date. So you really need to get your ducks in a row. But some of the issues talking about getting more time, there's a calculation of ownership interests that may have to be conducted, and that's not a straightforward process. There's locating, beneficial owners. Maybe it's difficult to pin people down. People are on vacation. People are, unreachable. There's locating beneficial owners abroad, which can be a very tricky thing. There's the time lapses that we specifically talked about. There's getting a determination of whether the company that you have is exempt or not. So all of those things people were asking, hey, look, if I have these issues, can I get an extension to the 90-day period or the 1-year period? FinCEN basically said, no, there will be no extensions that we're going to offer at this point in time. We do understand that there could be these issues that pop up that may cause you to need more time, but we'll provide, potentially FAQs to help try to clarify as time moves on, and there may be additional guidance or relief. But just like the rule of thumb for tax returns, I would tell a lot of people that are listening, file before the due date, or get your trigger point, figure out your due date, and file with the best information available. And then there will be there's a time period where you can make corrections or updates and still be okay. And I think use that extra time within that time period to make those corrections or updates as part of your timeline, if that's the case. Okay. And that's what we have here. Okay. So what happens if the BOI report needs to be updated or amended after it's been filed? So for example, if the beneficial owners have changed, so you've sold the company, you sold your interest in the company, or maybe someone has passed away, or an address has changed, or something of the identifying information is no longer accurate. So basically, there will be a 30-day time clock to update, correct, or amend your BOI report once you know that something is different. Now, what I was talking about previously, which is that you don't know all the information and you file, from the moment you file, you obviously know that your report is incorrect or incomplete. The 30-day clock begins at that point in time. But here, there's a different trigger point, which is something has changed. And from the moment that has changed, now you have a 30-day timeline to update or amend. Okay. Some other things to note. So for example, there's an exemption for beneficial ownership reporting for minor children, which we'll talk about later. Once that minor child becomes an adult, then an updated report has to be submitted because that person is now of majority age. So that's your trigger point, and then your timeline starts to file an updated BOI report. Okay. What specific information that is provided would trigger an updated report? Well, certainly if you change your name, so if I file a FinCEN report and my name is John Smith, and then I change my name to Jim Smith, then obviously I need to file an updated report with FinCEN. Same thing with an address change. But if I'm using my driver's license as my proof of image, and again, we're going to talk about what the requirements are here in a minute, but if I'm using a driver's license and it has an expiration date and I've updated my driver's license because it's about to expire, but nothing else has changed other than a new expiration date, that does not trigger an updated or corrected filing requirement. Also, if I'm taking a new picture, that does not change or update the filing requirement. Okay. There's a safe harbor for correcting inaccurate reports, which is 90 days. So that's different from updated reports. Updated reports are 30 days. Inaccurate reports would be 90 days. There is no good faith or other standard that FinCEN is allowing anyone to apply right now. So there will be probably more coming out about the safe harbor for correcting inaccurate reports. And again, it really depends on when did you know it's inaccurate. And going back to my first example, if you're filing with an incomplete or inaccurate report, you know that you're filing it inaccurate or incomplete. Your clock starts the moment you file that report. Okay. A couple commentators wanted to know what happens when a company is terminated or dissolves. Is there an updated report that needs to be filed? The answer would be no. Also, following along the same line, some people were worried that once you get, say, a FinCEN identifier, which we'll talk about, that even if the company is no longer in existence, you're on the hook for updating your FinCEN identifier for the rest of your life. I don't think that that's particularly the case based off of some of these answers that FinCEN has given about dissolving or terminating a company. Again, they want to limit the burden on the reporting companies and the beneficial owners as much as possible. They don't want to create an in perpetuity filing requirement for these folks. Okay. And here we have basically the law of what needs to be reported. So this is a snip of the code sections from the FinCEN rules on, if we look at the top part, basically that would be what a reporting company has to submit. So that's subsection B. And then for part 2 there, that would be for what an individual has to complete. Okay. We're going to get more into that here in a second. So the certification of BOI report issues, there was a lot of people that were concerned about the certification. So how do we look at, who's certifying the report? So when it's submitted, you have to certify it. So for example, if you've ever, looked at your tax return on page 2 when you're signing the tax return, now people are e-signing it on the form 8879, but basically you're certifying that tax return under penalty of perjury. The same thing here, you have to certify your BOI report. And the question is, what exactly goes into that? What's the level of due diligence that the person signing the report has to conduct? What about CPAs and tax preparers or attorneys that are preparing the report? What level of due diligence do they have to undertake? What assumptions of risk do they have? What about standards and practices for personal identifiable information, or PII? That's a really important one because there is liability for making sure that information is secured. So those are all issues about the certification process with BOI. I can say that when you are certifying the BOI report, whoever is signing that, you're certifying that as true, correct, and complete, which supposedly matches the language with IRS Form 8300. And also matches the FinCEN identifier requirements. But the way that the law was written, so 5336, the way it was written, the reporting company itself has the ultimate responsibility, and it cannot defer that responsibility to the individual who files the report. It cannot defer that to a tax preparer or CPA or an attorney. I will say that tax preparers or CPAs, even though the ultimate responsibility is with the reporting company, the requirements under Circular 230 still apply. Your state accountancy board rules still apply. For attorneys, your state bar licensing rules still apply. So keep in mind, if you're preparing the FinCEN BOI report, you still have to comply with those various rules. But the ultimate responsibility under the certification language for the FinCEN BOI report is with the reporting company itself. Okay. Getting back to the reporting company information. So if we go back a couple slides here to the law and basically what the requirements are for what needs to be reported. So this is where it comes from. This is it distilled into very simplified kind of format here. So what does a reporting company have to report on the FinCEN BOI report? So first off, it's got to report its full legal name, any trade names, any doing business as names. All of those have to be reported on the report. It's got to report the state of formation. It's got to report the current business address. And then there has to be a unique identifying number that it has to report. And generally, that's going to be an EIN number, okay? And that all sounds pretty simple, right? It sounds pretty straightforward. But again, when we start peeling it back, like what do we mean by some of these terms here? So for example, how do we define a business address? Like what does a business address constitute? Can it be a PO box? The answer is no. Can I use a third-party address? So for example, can I use my CPA's address or my tax preparer's address? The answer is no. Can I use my attorney's address? The answer is no. You have to use the address that's your principal place of business. That is how we define the business address for a reporting company, okay? And then again, if you're a reporting company with a principal place of business outside the United States, there's a whole different definition for that as well. So you kind of have to hone in on some of these specific requirements and really kind of get into the nuts and bolts of what's required there. Don't just make assumptions that you can use a certain, item to fulfill the requirement. You have to ask, okay, how do we define that? What will be proper for complying with that reporting requirement? Okay, what do foreign reporting companies need to provide? So, for example, if we're talking about a foreign reporting company, this is going to be a company that is registered outside the United States. It's going to be registered in a foreign jurisdiction, and they're going to be registered to do business inside the United States, okay? So they're going to be required to report their foreign jurisdiction wherever they formed at. So if they formed, for example, in the United Kingdom, then they would report the United Kingdom. They would report the place that they're registered to do business at in the United States. So typically that's going to be a state within the United States. And they're also going to have to report their US TIN, which is their taxpayer identification number. Generally, that's going to be the employer identification number or the EIN. If they don't have an EIN, which is common, there are a lot of foreign reporting companies that don't have an EIN. Then they have to provide their foreign taxpayer identification number. You will use that instead. So a lot of people have questions about what identification number would have to be used for a foreign reporting company. And FinCEN has promised to give more guidance on this topic. Okay. Some people want to understand what do we mean by the definition of state. So FinCEN has defined that state means any state within the United States, the District of Columbia, Puerto Rico, the Northern Mariana Islands, et cetera, et cetera, et cetera. Okay. What information is required to be filed for an individual? So for an individual, you need their full legal name, you need their date of birth, you need their current residential address, and you need their unique identifying number and an image. Okay, we'll go into that here in a second. But again, from the outside looking in, this seems pretty straightforward. But once you start peeling it back, there could be a lot of questions on what proper information is required to be reported here. Okay, so for example, for current residential address, since the pandemic, I've noticed a lot of people have become nomads, right? Or even what we call tax nomads, meaning that they're moving from location to location to location. They're not really in one place. Okay, there's also a lot of people using private or virtual mailboxes. There are a lot of people that use PO boxes. There was even some commentators that say, well, what if I have GPS coordinates? Could I use those? Which I thought was pretty funny. That is not, none of those are allowed to be used for current residential address. You have to use an actual current street address. And if you don't live inside the United States, then you have to provide your current street address in the foreign jurisdiction. Okay. How do we define the unique identifying number and image? Okay. And this one again raised a whole host of questions here. So what if, for example, I don't have a document with my image on it? Maybe I'm incapacitated, or I've got a medical condition that has prohibited me from updating my passport or my driver's license. Or where more importantly, some people may say, well, wait a minute, you're taking my image. What are you going to do with it? What are you going to do with a copy of my driver's license or my passport? Who's going to get that? Who's going to be able to utilize that? Who's going to see that? But basically, when it comes to what you need to provide, it's got to be either a non-expired U.S. passport. It's got to be it could be a non-expired U.S. state identification document. So not a driver's license, but rather just a state identification document, or a non-expired state driver's license. Now, if you don't get access to one of those three, if you don't have one of those three, you can use, if you have a non-expired foreign passport, you can use that, but you basically would not have access to one of the first three to be able to use the non-expired foreign passport. So it's got to be one of these four. That's what FinCEN currently wants right now. I'm sure that this will be more of an issue for them going forward, and they'll probably release more guidance on that. Okay, company applicants. This is one person or series of people that have to be reported on the FinCEN BOI report. So for example, we just talked about what the reporting company needs to report, and then what individuals need to report. Now we're getting into who are the individuals that we need to report on. The first type of individual that we're going to talk about are going to be the company applicants, okay? And company applicants are going to be any individual that has filed or registered an application for the formation or registration of the business entity. Typically, that's done in the state. So, for example, if I go to an attorney and I say, hey, I'd like to register a limited liability company in the state of Texas, that attorney then says, okay, I can do that for you. And I'm going to be the one that's going to be, basically setting that up for you. The attorney prepares all the paperwork, prepares the registration documents. Then the attorney then gives it to their paralegal. The paralegal then actually does the actual filing with the state. The company applicants in that particular situation are going to be the attorney and the paralegal, because the attorney is the one that basically has directed the filing of the documents, and the paralegal has been the one that's actually done the filing of the documents. Okay. And basically, for a foreign entity, it's a slightly different. It's going to be the person that basically registers the company with the state. So basically, if you have someone that's saying, look, I want to do business in the US, I'm a foreign company, and again, foreign companies typically doing business in the United States are going to file the Form 1120F, which is on the left-hand side of the slide. But again, whoever's doing or responsible for registering that foreign company to do business in the United States, that's going to be the individual that's going to be reported as the company applicant for that reporting company. Okay. Reporting companies generally need only update information concerning the reporting company or the beneficial owner. There is no current requirement to update information related to company applicants. So, for example, if you do your initial report, this is generally for new reports. This for entities created on or after January 1st, 2024. You will report your company applicants. That reporting requirement is not for existing. So anything before 2024, there's no company applicant reporting. But again, after 2024, January 1st, 2024, you do have to report the company applicants. If something changes with those company applicants after you report them, there is no requirement that you update or amend the report for that new information. It's only that first time. However, if the company applicant information was inaccurate on that first report, then there is a requirement to update the FinCEN BOI report for the inaccurate information that was initially filed. So again, there is a difference between updating a FinCEN BOI report for company applicant information. That's not necessary. But if the information was incorrect when initially filed, then you do have to update that report. And here's a handy dandy kind of flow chart. FinCEN has a small business guide. It's fantastic. I've snipped this out of that guide, but this is basically kind of a flow chart to help think through, okay, do I need to report a company applicant or do I not need to report a company applicant? And I'll have these charts snipped and kind of put into the presentation throughout. FinCEN identifiers. So I think a lot of people, my recommendation to a lot of people is that if you are someone that is being reported on the FinCEN BOI report, you're an individual, whether it be a beneficial owner or a company applicant, my suggestion is go out, get the FinCEN identifier. Instead of giving all the information that was laid out on that slide, full name, address, all that stuff, you're just giving the FinCEN identifier, and that's what's being reported. However, you're still giving that information to FinCEN. You're just doing it in a more direct format. You're doing it one-to-one with FinCEN, and they're producing a FinCEN identifier for you that then you then give to the person that's doing the FinCEN BOI report. Okay. Defining a domestic reporting company. So there's a different definition about domestic reporting company than there is foreign reporting company. So this is on the left-hand side of the slide. You'll see the law about what is a domestic reporting company. And then at the bottom, part 2 is what is a foreign reporting company. But generally, a domestic reporting company is going to be either a corporation or an LLC that is created by filing a document. The key there is that it has to be created by filing a document. So what is not a domestic reporting company? Well, a sole proprietorship will not be a domestic reporting company because they don't file any documents. Certain types of trusts won't be domestic reporting requirements, and certain types of general partnerships, because again, they're not filing anything to be created. Those will not be reporting companies, okay? Also, some people were asking about, well, what if I just register to do business as a sole proprietorship, but I'm not actually filing a document to create, the company? That by itself is not enough. Or what if I'm registering a DBA? That by itself is not enough to trigger the filing requirement. For a foreign reporting company, it's basically going to be, again, a business entity created under the laws of a foreign country. So again, it's not going to be as limiting as, say, the domestic reporting company. I think this is going to catch more foreign entities than it will domestic entities, because mostly foreign entities require registration or filing of a document with that foreign country. And they have to be registered to do business inside the United States. So those are the two requirements that would trigger a company to have to file the FinCEN BOI report. And once again, here's your handy dandy chart. So on the left-hand side, you've got your domestic reporting company. On the right-hand side, you've got your foreign reporting company. Okay. Reporting company exemptions. So there are some exemptions where basically Congress has said, look, you're already filing other things with the United States government. We don't need you to file again the FinCEN BOI report. It would be duplicative. Here is a snip behind the theory behind the exemptions. And basically what's happening here from the congressional record of the House of Representatives, again, they're urging people to say, look, we're interpreting the exemptions as narrowly as possible because we want the most amount of people to be filing the FinCEN BOI reports, okay? There also, a lot of people are asking, well, if I'm exempt from reporting, don't I have to report that I'm exempt from reporting? Well, believe it or not, at the federal level, there is no certificate or filing requirement if you're exempt. You have to kind of make that determination yourself and say, oh, I'm exempt, I don't have to file. There will be no certificates of exemption issued. Protective reports should not be filed. So that is one thing to be clear. You do not need to do any of that. None of that should be done. And then one thing that I thought was interesting, out of the 23 exemptions, they chose not to specifically exempt family offices. So that is not on this list of 23 exemptions. I will highlight only 3 of the 23 because I think they're the ones that are going to apply to most people. I think if you're a bank, you're an insurance company, or you're a broker dealer, you probably have gotten this covered. But for the large operating company exemption, I think that if you're a CPA, for example, and you do a lot of business entities, this is one that you probably want to look at very closely. So again, the business entity would employ 20 or more full-time staff. So that's a big requirement that you have to kind of make sure they have that. They have to have a physical office within the United States. And then they have to have 5 million or more of gross receipts, excluding gross receipts from sources outside the United States. So you have to look at the federal rules. What do we mean by sources outside the United States? And there we get into the source of income rules, right? But again, if you have those factors and they're filing the 1120, 1120S, the 1065, then there's an exemption and there's no reporting requirement. If you look at the bottom of the slide here, FinCEN estimates that about 300,000 plus folks will have to file or will meet the exemption to the filing requirement. So again, there's been a lot of thought that went into that exemption. Here's a handy dandy checklist to go through. And again, this comes from the Small Business Guide, but this is a checklist to kind of help yourself get oriented with the requirements of the exemption to see that if you qualify. There's also subsidiaries of certain exempt entities. So for example, if you're a bank and you have a sub, does that sub also qualify? The FinCEN did their research. They think there's about 77,000 subs that will meet the exemption for 2024. And again, there's a whole list of how that applies. Then there's this inactive entity exemption, which there's a laundry list of requirements that you have to basically fall into to not have this reporting requirement. So again, there's a handy dandy checklist that can walk you through that. Okay. Now let's get into the big juicy sections of the report, which are the beneficial owners. So who has to file here? So again, it's any individual, whether they're US or non-US, that directly or indirectly has A, substantial control, or B, owns or controls 25% or more of a US corporation or LLC that is filed with the state. Okay. That's who has to file. So how do we define substantial control? And I think this is a big area for where people are going to have a lot of difficulty understanding if someone has substantial control or not. So FinCEN basically has identified 3 different slices for substantial control. There's senior officers, which have the nominal authority. There's certain officers like board of directors that have de facto authority. And that falls into category 2 and 3. So again, they can appoint or remove senior officers. And then you have certain people that have the ability to direct certain important decisions, right? Can I enter into a contract? Can I terminate a line of business? Can I determine someone's compensation within the company? So what is a senior officer? So senior officer is generally going to be a president, CFO, COO, general counsel. Those types of folks are going to be C-level individuals are always going to be senior officers. Okay. And one of the questions that was asked is, what about tax professionals? If I have a tax professional that has executed the Form 2848, declared themselves to be my representative, would they be considered, someone that has substantial control? The answer to that is no. That by itself is not enough to trigger the reporting of a tax professional. Any kind of representation or agency agreements typically are not going to rise to the level of reporting of that person on the FinCEN BOI. Here are a couple straightforward examples. And again, these slides will be available for everybody. I'm not going to go into them, but basically I've got two straightforward examples that people can look at about substantial control if they want to learn more about how those rules work. And then here's your little chart about substantial control indicators and kind of how to walk through if someone does have substantial control or not. And then here's a checklist, that you can use to go through, okay, does someone have substantial control? Should they be reported? I think even worse than determining if someone has substantial control, and this is really tricky in some cases, is does someone have the 25% or more beneficial ownership percentage? And there's so many different things to look through here. So for example, if we look on the left-hand side of the slide, how do we define an ownership interest? Well, again, if I own equity or stock, if I have a capital or profits interest, so maybe I've given someone, maybe they're not an equity partner in my firm, but maybe they're just getting a share of the profits, they're a profits partner, that could be construed as having an ownership interest under these rules. Convertible instruments, I mean, this was a big one. What if I have the instrument that's going to convert my ownership at some future date, or a warrant or right to purchase at a future date? That could be construed for that as well. Puts, calls, straddles, and other options. With that particular requirement, though, there has to be a knowledge requirement. If you look at that subsection D there, I kind of circled it in red, except to the extent that such option or privilege is created and held by the third party or third parties without knowledge of the reporting company, which can happen. Those happen a lot of times. Reporting companies may not know that certain puts, calls, straddles, or other options are created. They may not have that knowledge, but if they have that knowledge, then that could trigger a beneficial ownership reporting requirement. On the right-hand side, we talk about how ownership or control interests can also be determined through joint ownership. If a trust is involved, so let's say a trust owns a reporting company, is the trustee someone that has to file? Is the beneficiary someone that has to file? Is the grantor someone that has to file? And what about a bunch of intermediary entities? So what if we have, a chain of 6 reporting companies? How do we determine, if there is a beneficial ownership percentage there? Here's some comments about the convertible instruments that I just talked about. And then here is basically how they want people to calculate the ownership interests of the 25%. So again, the subsection says, hey, look, this is how we're going to calculate it. So we're going to look at the ownership interest at the present time for equity or options. We're going to look at your capital or profits interests. For corporations that have a chain, we're going to look at, and this is specifically C corporations, the greater of the voting power or the combined value. And then we're also going to look at facts and circumstances. So again, there's this whole chain of like, how do we calculate the 25%, which is super, super complicated. And here's your chart on how to do that. I have a slide that I'm going to reference here at the end about where legal determination, so where, say, a tax preparer or CPA's kind of involvement would start and stop and where you need to get a legal opinion. I think if you have a complicated structure where it's difficult, it's not readily apparent or easy to calculate the 25%, I think that kicks it right out of the realm of a tax preparer and right into the realm of the seat of an attorney. And that would be a legal determination. Okay, you're a 25% beneficial owner, you're not a 25% beneficial owner. I think that's clearly an area that you want to get an attorney involved in and basically say, there's a limit to the scope of services that we can provide and determinations that we can make for this report. This is one of those areas clearly that should not be made by a CPA or an accountant. It should be made by an attorney. Okay, and then there's your checklist to go through that. There are exceptions to beneficial ownership reporting, and I'm not going to go through all of these. These are your minor child exceptions, certain nominees, certain future interests of rights of inheritance. Those are again areas that you can look at more with the slides later on. There are reporting violations. So if you don't file the proper information or you willfully hold up people, so people are like, I'm not going to give my information, I'm not going to comply with the reporting requirements, that could cause the reporting company to be out of compliance with filing the FinCEN BOI report. And then that could trigger liability, on the senior officer of the entity or the person that's not giving the information to make sure that the report is filed accurately and timely. So just be aware that while the reporting company does have the ultimate responsibility, if there is an individual that is taking proactive steps to impede the filing or not providing information, that person may also have some liability as well with the reporting violations. Okay. And when it comes to what that liability is, it's typically $500 for each day that the violation has occurred, up to $10,000. And again, FinCEN loves their $10,000 penalties that they love to adjust with inflation. Okay, some background and context by the numbers. So I think that FinCEN is anticipating that there will be 32 million reports filed in the first year, so here in 2024. There will be 5 million reports filed thereafter. But the number of reporting companies is actually higher than that. So 36 million in year one, about 5.6 million in thereafter. But there's some exemptions that will play into all of this. They estimate that about 60% will have simple structures, whereas about 5% will have complex structures. And again, FinCEN did it. I mean, if you read the regulations, it's long. I think it's 213 pages, but they did a fantastic job kind of walking through where they're pulling the data, how they made these determinations. Whether you agree or disagree with their kind of, outcome here, I actually think they did a fantastic job. I do disagree with some of the things they have in there because I don't think they properly thought through some of the things, but this is really, really great data to have in mind. There is a cost or a burden or a cost to the government as far as the number of reports and how much time, effort, and energy will go into this. Then on the right-hand side, you will see the staggering cost that this will impose upon the United States government. And there have been a lot of commentators that said, look, I think that, with the compliance costs by reporting companies and by individuals, I think the key here is that FinCEN may have underestimated the amount of time, effort, and energy that will be needed to do these reports. Some people believe that FinCEN is underestimated by a factor of 10, meaning that if FinCEN estimated, say, 70 minutes or 4 hours to complete the report, and I think that's the delta which they gave from the simple structure to the complex structure, by a factor of 10 makes a massive difference. 40 hours versus 4 hours is quite a difference there. I think time will tell as we get into this first year and we start doing some of these reports if they actually take what FinCEN thought they would take, or actually a lot longer. Okay. This is the slide where basically these are the areas where I think you may, if you're a CPA, EA, tax preparer preparing these reports for your client. And I think if you get into these questions, I think this is where you may want to consider calling a pause and telling your client that they need to get a legal analysis. So if you have a foreign pooled investment vehicle that's registered to do business with the US, that requirement by itself, I think you want to get an attorney involved on how to comply with that. Determining of exempt, when an entity goes from being exempt to non-exempt, you may need to get a legal opinion on that. Determination of substantial control, when you have, a trust involved. I think a lot of the trust companies out in, say, Wyoming, and those places, they're going to have a lot of legal counsel kind of going through about when they have to report their trustees or not. Calculation of beneficial ownership, I talked about that when you have convertible instruments. Calculation of beneficial interests when you have trustee, which I just talked about. Determination of a domestic reporting company at the state level, the rights of inheritance, the right to receive payment in the future, and again, getting an exemption qualification. I think that those are all things that you want to get an attorney potentially involved in. And so again, I think if you're on the fence about making that determination with your client, it's really a head scratcher. It could go either way. that's probably, the world telling you you may want to reach out to an attorney and get, a legal determination on that. And if you need help with doing that, I know of several good attorneys that are deep into this exercise that have spent a lot of time looking at these rules that I think would do a great job at giving advice on this. I do want to reiterate what I talked about at the very beginning, that the FinCEN BOI rules is one of 3 rulemakings under the Corporate Transparency Act. The second one was the access rule. The third one is updating the 2016 CDD rule. So again, we've had the first and second one occur. The third one, CDD, we don't know, but we think sometime in 2024. The access rule, which just came out, which I think a lot of people will probably be interested in once they've digested the FinCEN BOI rules. But basically, that final rule was issued on December 21st, 2023, and it goes into effect on February 20th, 2024, and it's going to be released in tranches about who gets access. But basically, 2 things I pulled out on here. If you're a foreign requester, which is typically a foreign government, at the moment, in order for a foreign requester to get the information, they're going to have to go through FinCEN and use an intermediary U.S. federal agency. And the request is going to have to be pretty detailed about what it's for. And it's going to have to be something in the long lines of law enforcement in that foreign country. And it's going to have to apply to some kind of international treaty or offset by the authority of a trusted foreign country. So there's a lot of moving parts there. And I can see a lot of interaction with, the competent authorities, with the IRS that do a lot of that work. They do a lot of the MAP requests and treaty requests. I can see that being them working in conjunction with a lot of these foreign requesters. And then Treasury personnel, which I think this is also an area that we have to be very, very careful with, meaning that the IRS may be able to access this information so that they can do their own audits, enforcement of penalties, because again, FinCEN can't enforce any penalties. But all of that, they'll be able to have access under the access rule to this information. And again, it's something to be careful with. And specifically what I mean is, and this is a good example, we have the Form 5472 filing requirement for foreign-owned U.S. disregarded entities. So for example, if I'm a foreign person and I create a U.S. LLC and it's a disregarded entity for U.S. tax purposes, I'm required to file the Form 5472 along with the pro forma 1120 page 1. If I don't file that filing, it's a $25,000 penalty. I may also be required to file the 1040-R, the non-resident tax return, report the income on Schedule C. And then the third filing I may have to do now is the FinCEN BOI report. And if I don't do one of those correctly, Treasury or the IRS may be able to use that in an audit on all 3 of these filings. Again, you've got the sandwich penalties of the FinCEN BOI $10,000 and the 5472 $25,000. So there's a real impetus here for these types of folks to make sure they're doing all of that correctly. I would also note that you have certain tax exempt individuals that are residing inside the United States but considered foreign. So when I think of this, I think about diplomats that are under the A1, A2 visa. I'm thinking about international organization employees under the G1, G4 visa. I'm thinking about potentially students that are in their first years of non-residency under the F1, J1, M1 visas that have, again, U.S. LLCs that are single member LLCs that are disregarded, for U.S. tax purposes. They would meet the holy trifecta here of filing this plus the FinCEN BOI. Okay, states. So states are also getting involved. We have the New York LLC Transparency Act, the NYLTA. This was signed into law by the governor of New York at the very end of 2023. This is a little bit more narrow in scope as it only applies to an LLC that is formed or authorized to do business in the state of New York. You actually have to get an exemption certificate to not file with the state. Other than that, though, they're largely following the FinCEN BOI, the CTA, so the federal rules. There was a lot of hubbub about the fact that the original law had this public access database where basically once the report was filed with quote unquote the New York DOS, that anyone would be able to search it and figure out who the beneficial owners are, minus the PII, the personal identifiable information. That when the law was signed in, there was an amendment made there that the database will only be available to certain law enforcement at the federal, state, and local levels, not a public database. So There's more on that coming out soon from the state of New York. This, though, the reporting requirement for this starts on January 1st, 2025. So if I have a New York LLC, I may be required to file my beneficial ownership report with both New York and the federal. So you may have two reports that you have to file. We also have some other states that are currently getting involved. You have the state of California, state of Massachusetts, and the state of South Dakota all have pending legislation on this topic. And I think other states will follow suit as time moves on. So this isn't going away anytime soon. This may be both in effect at the federal and the state levels. And then what I would tell a lot of people, especially tax practitioners and attorneys that are working on filing these reports, if you have comments or complaints or suggestions, don't keep those to yourself. FinCEN's actually pretty good at taking those comments and talking about them. They may not implement them, they may not go forward with them, but they're very good at digesting them and then coming back out and talking about them. Email FinCEN, email them on those and give them your thoughts and your comments. It only helps make the process better for the people that actually have to file these forms and then the practitioners that are helping people with this stuff. And I know I've gone a little bit overboard here. I've gone about 7 minutes over, but we got a couple more minutes here for questions. If anyone has any questions, I've not seen any questions pop up, but if anyone has any questions here, I'm happy to take any Q&A at this point in time. I will also leave up my contact information. At the Wolf Group, we are helping to prepare the FinCEN BOI reports. So if you have a report that needs to be filed and you need help with it, or if you're a professional services firm and you have clients that need the report to be filed and you need a referral on that, please let me know or please let us know. This is our contact information, and we're very happy to get involved and see if we can provide assistance there. At this point in time, I don't see any Q&A, which makes me think that I've done my job to 1,000% today. I've answered everybody's questions with my slides. I know it was a lot of information to digest, but as I said at the beginning of the presentation, everyone's going to get a copy of the slides. This will be on our YouTube channel as well, so you will be able to access the video and go back and look at it if you want to learn more about, if you want to rewatch it and kind of get into more of the slides that I talked about. I do appreciate everybody's attendance today, and thank you for joining us.